Hi, YouTubers. I want to talk to you a little bit about New Jersey's sport betting case since it's going to be heard by the U.S. Supreme Court in the next session. For those of you that are unfamiliar with it, New Jersey's sport betting case revolves around a constitutional challenge being advanced by the state of New Jersey to a piece of federal legislation which allows sport betting to occur in certain states but not others. New Jersey being one of the states that is not permitted to hold sport betting. And the argument that is being advanced by the state government is that the legislation diminishes the doctrine of equal sovereignty, which is possessed by all of the 50 states. For those of you that aren't familiar with it, I don't expect many people to be familiar with it unless you've really been a bookworm when it comes to constitutional law, inside, outside, and diagonally, horizontally. But anyway, the doctrine of equal sovereignty basically means that each of the 50 states, having ceded certain aspects of their sovereignty by being admitted to the Union, essentially retain other inalienable aspects of sovereignty under the 10th Amendment. Now, to be honest with you, and to be very truthful, I think New Jersey's argument fails. Because in this aspect, states' rights and equal sovereignty isn't an issue. In this regard, the United States Congress has exercised its Article 1 authority under the Commerce Clause and has essentially promulgated a federal law which they've decided is in the best interest of the national economy and interstate commerce. They're allowed to do that. If you accept New Jersey's argument on its face, what you're doing is you're essentially saying that whenever Congress enacts a piece of legislation to regulate interstate commerce, that they have to make sure that there's no disparate effect and between any two states. That's preposterous. And I'll give you an example that shows why it's preposterous. For those of you that don't know it, Congress regulates the amount of crops that can be domestically grown without a farmer being subjected to an excess tax for growing the additional crops. Well, let's say next year Congress says that the state of Idaho and that farmers in the state of Idaho can grow 30 tons of corn before being subjected to the excess tax. And farmers in the state of Iowa can grow 60 tons of corn before being subject to the excess tax. Well, that's a determination that's been made by the United States Congress that those quantities are what's appropriate to be grown in those areas for the purpose of accommodating the national need, foreign export needs, trade needs, and that those quantities are in the best interest of interstate commerce. Now, to that extent, there's a case that's even more applicable and that kind of shuts down New Jersey's argument without taking a breath. And that case is from the late 1970s, early 1980s. To give you a little background on it, when the Clean Air Act came into effect, the CAA, the federal government wasn't the only state that was regulating vehicle emissions. The state government of California had their own clean air emissions. And what happened was, to save face, even though the federal government could have said, hey, California, we're going to preempt you, and now you just have to follow federal regulations. But the federal government did not do that for a lot of reasons. What the federal government did was the federal government basically said that only us and only the state of California can adopt emission regulation standards under the Clean Air Act. And a lot of states challenge that because who is California to say what the proper vehicle emission is for their individual states? California's air quality isn't the same as Nebraska, and Nebraska's isn't the same as Wyoming's. And Wyoming's certainly is much better than New York, New Jersey, or Pennsylvania. But the U.S. Supreme Court ruled affirmatively that in that instance, California's regulation and the delegation of legislative responsibility by Congress to California was in fact permissible under the Commerce Clause. And for that very reason, I am positive. I shouldn't say positive, but I think very strongly that New Jersey is going to lose the sport betting case in front of the Supreme Court for very principled reasons, mind you.